Please, Your Lordship.
Yes.
Lordship, I beg to mention item 24.
24.
Lordship. Lordship, the Standing Council is in the period of bereavement. So kindly listed the matter, Lordship, after 4 weeks. And I took the consent of the petitioner as well, Lordship.
You are Mr.?
Penyang Nishing. For respondent 5 to 11.
Appearing for the respondents 5 to 11 states that the leading counsel in the matter is in bereavement and consent of the counsel for the petitioner has been taken to seek an adjournment today.
4 weeks, Lordship.
For 4 weeks. Prayer is allowed to list a matter after 4 weeks. Yes.
Please, Your Lordship. Lordship, I beg to mention item 21 and 22.
21
I've taken the consent from the opposite party. I pray that the matter may be listed after 3 weeks, Your Lordship.
Why the adjournment?
I have some personal difficulties, Your Lordship.
You are appearing
For
for
the
the
state respondents, Your Lordship.
Okay. Mr. So-and-so, appearing for the state respondents, states that he has some personal difficulty today, and with the consent of the counsel for the petitioner, prays for the matter to be listed after
3 weeks, Your Lordship.
3 weeks.
Item 21 and 22.
Prayer allowed, list the matter after 3 weeks.
Your Lordship, in item 22, there is an interim.
Interim orders, if any, would continue. That will be in item 22.
Your Lordship, I would like to mention item 23 on behalf of Ms. Inaoli, government advocate. As she's indisposed, I pray that the matter may be listed after 2 weeks, Your Lordship.
A prayer is made on behalf of the counsel for the respondents with consent of the counsel for the petitioners to list the matter after
2 weeks, Your
2 weeks. List the matter after 2 weeks. Yes.
Your Lordship, also item 9 on behalf of MS Inaoli. You have to receive instructions, so
No.
pray for 3 weeks, Your
No,
Lordship.
no. Contempt matters will take up when it reaches.
Your Lordship,
Contempt matters, no adjournment.
obliged.
Yes. Yes, madam.
Please, Your Lordship. Your Lordship, I beg to mention hearing item number 25.
25. Okay.
Your Lordship, I humbly pray it may be listed after 2 weeks.
You've informed the other side
And for the petitioner.
on a prayer made by the counsel for the petitioner with the consent of the government advocate. List this matter after
3 weeks, madam.
3 weeks.
Obligement.
Yes.
Please, Your Lordship. I beg to mention item 10 on behalf of the Procedural Council. He is indisposed, so kindly list the matter after 2 weeks.
Counsel for the petitioner.
Counsel for the respondent number 2 to 5.
You have taken the consent of the petitioner. You are doing for the petition. On a joint prayer made by the counsel for respondent number
2 to 5.
2 to 5 and the counsel for the petitioner, and list this matter after
2 weeks.
2 weeks. Yes, that was item 10. Okay, next.
Please, Your Lordship. Lordship, I beg to mention item number 5, Lordship.
5.
Yes, Lordship. Lordship,
Yes.
my senior leading counsel is out of station, Lordship. So let the matter be fixed on Tuesday.
It's a bail.
Yes, Lordship. However, my senior is out of station for some personal work, Lordship.
Why don't you take a chance? Maybe we go through the documents and grant you the bail. I don't know. You want your senior to appear in the matter? Okay. But you see, a person is behind bars, is it not?
Yes, Lordship.
On a prayer made by the learned counsel for the Mr. So-and-so appearing for the learned counsel for the petitioner, list this matter on
Tuesday, Lordship.
26/8/2025.
Lordship, similar prayer for items 6 and 7, Lordship. These are
Hey,
bare
you are
matters,
letting all
Lordship.
these persons stay behind bars. Eh?
Lordship.
6 and 7 same.
Lordship, let the matter be listed after 2 weeks, Lordship. These two.
These people are behind bar. Why are you prolonging their agony? These are bail petitions, no? Read petition, fine. Take time. Bail petition, you should. I don't know. Same in 6 and 7.
Lordship, I also would like to mention hearing item 15, 16 and 17. Lordship. So 15, 16, Lordship. 15 and 16.
What is the matter about?
Lordship, this matter pertains to regularization of work charge employee, Lordship. And Lordship, similar matter is pending before the division bench during writ appeal 3 and 4 filed by the state respondents, Lordship. So that this matter may be
Can you stay in that appeal?
Yes, state has made an appeal.
No. Has the division bench granted any stay in the matter?
No, Lordship.
No. So you should take the chance, get your matter disposed of.
Similar
saying that
prayer, Lordship.
There is already a judgment which is not under stay. Let the state file another appeal. Why don't you do matters? Yes, in item number 15 and 16, on the prayer of the learned counsel appearing for the petitioner, list this matter after?
Lordship, after the disposal of
After the disposal of writ appeal number
3 and 4, Lordship.
3
of
and 4 of
2025.
writ appeal 3 of 2025 and writ appeal 4 of 2025. Learned counsel appearing for the state does not object to the same. Accordingly, list the matter after disposal of the writ appeals. Yes.
I am obliged, Lordship.
Yes, Lordship.
Yes, sir.
My Lord, it appears that the counsel, which is item 17 from the hearing list, my Lord.
17, criminal
Yes, I
appeal.
am for the appellant here. Here it seems that the counsel, who was the amicus curiae, South of Station has
Yes,
mentioned by.
yes, Lordship.
So, the matter can be taken up on 25th. 25th.
Item 17, on a joint prayer made by the counsel for the parties. List this matter on
Monday, 25th August.
25th of August 2025. Yes,
Obliged, Lordship.
that was item 17 you mentioned.
Yes, Lordship.
Criminal appeal jail. Okay. Yes.
Please, Your Lordship, I'd like to mention item number 11 in jail.
11.
Yes, Your Lordship. I'm appearing on behalf of my senior counsel. Kindly allow 3 weeks' time to file the objection against the continuance of delay.
You are appearing for the respondents.
Yes, Your Lordship. Response
Yes,
number
sir.
1 to 4.
Miss So-and-so appearing for the respondent number 1. Prays for how much time? 2 weeks.
3 weeks' time.
3 weeks time to file their objection to the application filed for condonation of delay. Prayer is allowed, list the matter after 3 weeks.
Your Lordship, similar prayer for item number 13.
13.
Since notice upon respondent number 4 and 5 is still awaited.
No, on whom it is awaited is another issue. You are appearing for someone
Yes, Your Lordship.
and you want to file your objections.
Respondent, I'm for the appellant, Your Lordship.
So you want to file your objections to the
Yes, Your Lordship.
same. Yes. Any more?
Lordship.
Yeah, please, Your Lordship.
Yes.
I'd like to mention item 27 on behalf of my senior. Your Lordship, my senior is in bereavement, so the matter may come up on Thursday.
It is submitted at the bar that the counsel for the petitioner is in bereavement, and with the consent of the,
Your Lordship, it's a motion matter.
it's a motion matter, is in bereavement. List this matter on
Thursday, Your Lordship.
Thursday, will be 21st, 21/8/2025.
Your Lordship, I have a similar prayer for item 20. This matter may come up after 3 weeks.
In item 20, you write, it is submitted that the learned counsel appearing for the petitioner is in bereavement. With consent of the counsels appearing for the respondents, let this matter be listed after 3 weeks on a date to be fixed by the registry. Yes.
May I please, Your Lordship, I beg to mention hearing item number 19, Your Lordship.
19.
Yes, if the matter can come up after 2 weeks. I've
Why?
taken consent.
You have taken the consent, but it is a 2022 matter. What is the matter about?
It's regularization of service.
And why do you want an adjournment?
Since my senior will not be able to come today, Your Lordship.
Item 19.
Yes.
Item 19, it is submitted by Ms. So-and-so that the leading counsel in the matter is indisposed today, and she prays for an accommodation for
2 weeks.
2 weeks. Let the matter be listed after 2 weeks on a date to be fixed by the registry.
Much
Yes.
obliged, Your Lordship.
Any more?
Please, Your Lordship. Lordship, I am for the petitioner in item 18.
18.
18, Your Lordship.
18,
I
why
pray that
please?
2 weeks' time may be given, my Lord.
Yeah.
The leading counsel is indisposed today.
The entire hearing list is gone. You see, we have got very little to do here, and we take our pain to go through the files in the evening or in the morning.
Understand?
You should be taking your chances, why not? Item number 18.
18, my Lord.
18. A prayer is made on behalf of the learned counsel for the petitioner that the matter may be taken up after
2 weeks.
2 weeks as he is indisposed today. Let the matter be listed after 2 weeks on a date to be fixed by the registry.
Obliged, my Lord.
Yes.
One motion, item number 1.
Please, Your Lordship. Lordship, this is regard to question of the fire.
Oh,
Lordship,
yes.
In the last occasion, the court has directed to bring the record of FIR. And I have filed an additional affidavit where FIR is annexed in annexure A1, page number 4. Lordship, the alleged accused here was charged under section 457, 380, and 34 for housebreaking and stealing of mobile phones, Lordship. Lordship, here the accused was arrested and was granted bail by the Honorable Court, and charge sheet was also produced and prima facie case was found in this matter, Lordship. And thereafter, there is an amicable settlement between both the parties where the alleged accused submitted their lost items to the complainant, and the complainant also willingly accepted the lost items, Lordship. And Lordship, here, since your Honorable Court has possessed inherent power under CRPC, paying for washing of the fire, Lordship, here in landmark judgment.
Yes. Please take us to the judgment.
Lordship, in landmark judgment of the Supreme Court, Jayan Singh versus State of Punjab, paragraph 57, page number 29.
Paragraph 57.
Yes, Lordship. May I please read out the relevant
Please
portion?
read the relevant portion. Yes.
Lordship, here it is stated that there is no statutory limitation with regard to the inherent power of the High Court, and also there is no category. No category can be prescribed, Lordship. And
This is basically on the issue that not only compoundable offences, but any offence can be quashed.
yes, Lordship. Here. In relation to this case, the Honorable High Court of Punjab and Haryana, as well as the High Court of Sikkim, Gangtok, has referred to this judgment and then released the same offences, same charges which was charged under section 380 and 57, Lordship. I have appendix there. Order. Lordship, since it is fit to be considered and is under the purview of the inherent power, it is my humble prayer that Honorable Court.
What was the offense here? 528.
In the High Court of Sikkim, Gangtok, it was charged under section 380 and 457 as well.
No, that was High Court of Gangtok says it's about committed theft. Indian Singh. High Court of Gangtok, etc. will be persuasive, very well. Tell me how someone, when he breaks into a shop, steals mobile phones, sells it off to people. Can we quash an FIR or a proceeding on that line?
Lordship,
Stealing 500 rupees, 1000 rupees is another issue.
Lordship, we have submitted our verbal submission before the Honorable Court Chief Justice and the Honorable Chief Judicial Magistrate First Class. She granted us some time for question of her Lordship.
Come to page 8 of the Gangtok judgment. CRP, it starts with the word CRPC, the top paragraph, no? And nonetheless, we reiterate that such powers of wide amplitude ought to be exercised carefully in the context of quashing criminal proceedings, bearing in mind, what is the first one? Nature and effect of the offense on the conscience of the society. Yes. Yes, who's appealing for the state?
357 part 2. This falls under 357 is part 2. So I don't know whether this will be proper to quash because this is not the last remedy that is available to the petitioner. They can go trial if.
No, I think the petitioner in this case are both the informant and the accused.
That is there.
So if the informant is already hand in gloves with the accused, what kind of a conviction can you gather at the trial? Will there be any conviction in the trial if they are already compromised and okay, we will not lead evidence type of a thing? Because that is what the agreement says. If you see, they will not pursue the matter, is something like that. The first part, page 17 of the, you have the brief with you. What does 357 say? Okay, page 17. First, let us come to page 17 of their agreement. Withdraw the case at page 18. Withdraw the case and shall not process for further legal proceedings in any legal court.
The crime is the other day my lord was observed, making observation that the crime was made against the state.
Yeah, it is true. But then he is again depending on this Gangtok judgment, which was also a case of theft in a dwelling house. And the others are lurking, trespass and housebreaking by night. Now the Gangtok High Court says, you give him a copy of the judgment, let us be on the same page. If you come to page 11, para 9. It is seen that both the offences under section 380 and 457 are not heinous offences of mental depravity or offences like murder, rape, dacoity, etc. They are not offences under any special statute like the Prevention of Corruption Act. But you see, here is a case where a person breaks the
Yes.
locks of the shop at night, takes away everything inside the shop. Is it not heinous?
And right or
He
wrong,
is returning today, tomorrow he will steal someone else's, again he will come back with a compromise petition. The recovery which I had seen the charge sheet, the recovery was not of all the amounts that were stolen. But the agreement says I have been returned everything. Even the police was not able to trace out some of the mobiles. Have you seen the charge sheet? Page 16. Page 16, the second paragraph, last few lines. There's a rupees 500 each. Can you see? 1, 2, 3, 4, 5, 6 line from the bottom of para 2. Starts with the date dated 29/2019. Can you find it? Then it says, further it is ascertained that the arrested accused Kulo Singh had stolen 3 numbers of phones from the repairing shop and sold it later at a, what is a booze joint? Booze joint located at New Market to some unidentified strangers by rupees 500 each. Efforts have been made to identify the purchaser to recover the mobiles, but neither the purchaser nor the mobile phones could be identified and located. Even the phone IMI numbers could not be ascertained. You have to convince me that this is a crime which is not against the state, which is not heinous. Otherwise, you'll have to take a chance in the trial. In the trial, your informant or the other witnesses, they don't give proper evidence. That is your luck. But
Lordship,
Yes.
since the Supreme Court has already given
that
the-
is what I'm saying. The magnitude of the crime. Breaking into a shop, lifting someone. This Gangtok case, it was lifting something which was on the windowsill. He saw it. He took it. He picked it up and he went away. So fine. Court says we forgive you. Here is a case where the intent is to break into a shop, steal everything inside. You have to convince me that under these sections, the sections are again the same, sir. What to do?
thing is here that
380 and 457. 380 and 457. Gangtok and this FIR.
Lordship, but this, with due respect to the Honorable Gauhati High Court of Gangtok, it's not binding on our court.
That is what I said. It is persuasive. It is not binding. I agree. And that is why I want him to persuade me some more.
In this case also, it has referred to the Supreme Court judgment.
True,
where I
true,
have
true.
submitted the
But then the
guidance.
Gangtok High Court has also taken into account the fact that this person did not enter anywhere. He just found a bag lying on the windowsill, he picked it up and he went away.
And here, one difference is, as my Lord has already pointed out, we have the purchaser and receiver, third party. We never know if the two,
The misuse it could be put to.
the accused as well as the complainant. Now the issue arises whether they are part of the conspiracy. So I think it's fair that they go back to trial court and sort it out sort of that matter in the interest of the justice.
Do you have anything to show that in case of housebreaking? Because you see, I can show you another thing. Please come to page 12 of that Sikkim judgment. You have that Gangtok judgment. Page 12 of it. You give him a copy, sir. Share the copy with him. I don't think he has got a second copy. Page 12. The fourth line from the top. The evidence suggests that the accused petitioner had not physically entered the building but stolen the bag lying in the window sill. It cannot thus be said that he committed lurking, house trespass or housebreaking by night. So you have to convince me a little more. I am with you. I don't want the state machinery to run around trying to prove a crime when both parties are, what do you say, friends. I don't want to do that.
Lordship,
My
since,
judgment also has to be supported by something.
Lordship, I have submitted the judgment of the High Court, Punjab and Haryana High Court.
Punjab and Haryana High Court is, what did they do?
Even here, the accused was charged under 380, 457 and 411.
So the only thing that is in his favor is that the chances of securing a conviction is very bleak.
Yes.
Otherwise, these judgments actually don't support you. You see, even in that Gyan Singh case, page 29, the same thing the Supreme Court has also said. Court refused to quash the charge against the accused by holding that the court could not quash a charge involving a crime against the society when a prima facie case has been made out. Any antecedent of these two, earlier antecedent?
No, Lordship.
Nothing has come up. Okay, we'll pass orders on this. So this is disposed. We'll pass order on this. So is it disposed? I'll pass my orders in the chamber.
Motion supplementary process, item number 26.
Yes, sir.
May I please, Lordship? Lordship, this is an appeal under section 172 of the Motor Vehicle Act, 1988, Lordship. Lordship, the brief fake of the case is that the initial original claimant, Deep Gogoi, filed the claim petition for injuries suffered by him in the accident occurred on 2nd of June 2016. However, Lordship, during the trial of the case, after giving evidence, he died on 17/09/2021, which is a gap of more than 5 years, Lordship.
Okay.
So, however, later on, Lordship, the parents of the deceased, representing the minor daughter of the deceased, were substituted as claimant. Lordship, if I may be allowed to read this paragraph number 6, Lordship.
You tell me what is wrong in the. First of all, did you take any leave?
Pardon, Lordship?
Did you take leave in the tribunal to defend it on any of the grounds? No.
Lordship, we have filed our original statement.
It doesn't work. See, as far as I understand, section 170 puts an embargo on the insurance.
Lordship.
Did you take that leave? Okay, where is that impugned order? Let us see. Award. Page 30.
Starts from page number 21, Your Lordship, annexure 2.
So why do you say this order is wrong?
Your Lordship, initially
Eh?
the original claimant filed the claim petition
Yes.
based on the injury suffered by him.
Yes.
Even the substituted respondent, after after being substituted and filing a recast petition. In that recast petition, they have not adduced any medical evidence to show as to how the original claimant has died because of the accident, Your Lordship, after a gap of 5 years, Lordship.
Can you take that ground now? Do you have that Motor Vehicles Act? What is the judgment? Nicoletto, कौन सा था judgment? I asked this person to get me my iPad. You see section 170. Is it? You have a copy of that?
Lordship.
170. Kindly go through 170. What does it say? Impleading of insurer in certain cases. Have you got it?
Impleading insurer in certain cases, Lordship.
Yes. Where in the course? Please read it.
Section 170,
Yes,
impleading
yes.
insurer in certain cases, where in the course of any inquiry, the claims tribunal satisfied that Para A, there is collusion between the person making the claim and the person against whom the claim is made. The person against whom the claim is made has failed to contest the claim. It may, for reasons to be recorded in writing, direct the insurer who may be liable in respect of such claim shall be impleaded as a party to the proceeding, and the insurer so impleaded shall thereupon have, without prejudice to the provisions contained in subsection 2 of section 150, the right to contest the claim on all or any of the grounds that are available to the person against whom the claim has been made.
Yes. Now, the ground that you are taking up in this appeal
Lordship.
is that the claimant should not be awarded, or the claim was not properly filed, or whatever ground you have.
Lordship.
The only grounds that the insurer can contest the claim is without taking leave. The only grounds that the insurer can take is what? That it is not the insurer of the vehicle, or that the insurance suffered from some technical lapses or legal flaws. Any other ground you want to take, you have to take leave in the tribunal itself, number one, to defend it as if you are the owner or the driver. You will be given leave only if there is a collusion between the person making the claim and the person against whom the claim is made, or the person against whom the claim is made does not defend his case properly. Then the insurer can come in. So there has to be an application in the tribunal, to my understanding, to grant you leave to defend. Unless there is that leave, you are the person who will only pay the amount. Can you come up to challenge it in appeal, saying that this was the mistake in the proceeding, that was the mistake in the proceeding? Those grounds may not be available to you. Nicolota Rohatpit, something like that. What was the judgment? Let me see, 170. You find it anywhere. I can issue notice, I can
Lordship.
keep it hanging for some time, but ultimately, what will happen, no? You deposited that statutory amount?
Lordship.
Deposited?
Lordship.
Okay. What, mister?
Medovero, Lordship.
Sorry, you'll have to be a little slow.
Pardon, Lordship?
Your name again?
Medovero.
Okay. Medovero.
Lordship.
Okay. And the counsel appearing for the appellant. This appeal has been preferred by the insurer against the judgment and order dated 23/5/2025 passed by the honorable member, Motor Accidents Claim Tribunal, Dimapur, Nagaland, in MACT case number 215 of 2016. Issue notice to the respondents, returnable in by registered AD, returnable in so and so. List after the issue notice, but yes, you
Issue
want to-
notice after 1 week, Your Lordship, and returnable after 4 weeks.
yes, you take your steps within a week.
Yes.
Steps within 1 week. Registered AD बोला है ना उसके बाद. After the registered AD, steps within 1 week. I am not convinced that you can file this appeal. I am not saying anything as of now.
Lordship.
You look into that law,
Lordship.
Nicoleta Rohtagi.
Lordship.
Look into that law. So far as my memory goes, it says that the insurer may not be in a position to file this appeal.
Lordship.
Yes.
Much obliged, Lordship.
From supplementary for orders,
Yes, this was yesterday's matter. Yes, sir. I had to put on a later on in this order. You are asking for a posting based on a compromise.
My lord.
Most unfortunately, the Wakalatnama does not contain the signature of the second petitioner. So you are not appearing for petitioner number 2. If you go by the affidavit, you do not say that it is also being sworn on behalf of the petitioner number 2, since this is a compromise thing. So what do you want to do now?
Sorry, my lord, there was ignorance on my part. I take full responsibility, but let not my client be prejudiced.
No, that is why I did not dismiss it yesterday.
So my humble prayer, my lord, is that I may be given some time to make the necessary rectifications.
How can you make the rectification? You cannot rectify an affidavit.
My lord, if I may be allowed to file afresh.
You can do 2 things. One, you can file an additional affidavit
My lord.
by the petitioner number 2, saying that she also supports the criminal petition number 1. Then she also has to file a Wakalatnama.
That we can do, my lord.
Or you can withdraw the whole thing, file afresh with everything.
Addition.
Which
My
one
lord,
do you want to
then,
do?
I may be allowed to file additional affidavit, and also I will do the same within 2 days' time.
Even then the petition will remain defective. Initial filing will be defective. I think you should withdraw, file it by the next 2 days. File it day after tomorrow.
My lord.
Get it listed on Friday. Get it listed on any other day as urgent. Because I don't think, what is the next date? Any next date given? Any next date by the lower court? Any date of appearance in the lower court, anything given?
My lord, we can file it by tomorrow afresh.
Then I'll say, when the matter was taken up today, Mr. Y. Humso, that is how you pronounce it, Y. Humso, prays that he may be allowed to withdraw this petition due to some defects in the filing, with the liberty to file afresh prayer not being objected to by the learned PP. It is allowed. This petition stands closed on withdrawal with liberty as prayed for. Otherwise you have a case, but I cannot do this.
Understand, my lord. Much obliged.
admission, item number 23.
Let's see.
My lord, let this matter be taken after exhausting the part one ethics. Because here, on last occasion, counsel for appellant is insisting for taking up the appeal matter along with the IA.
Yes, Your Lordship.
Okay. Okay. Take it after the, we take it up at the end of the list. Will that do? End of the list? Yes.
Item number 4.
4. Hearing me, I think one or two matters are only there, rest, only one is there. Any which way is no difficulty. Whenever the councils are raised. Yes.
The direction and the order passed by this court has been complied with.
It has been complied. What was the direction?
Lordship, direction was to conduct an inquiry as to whether respondent or respondent in the writ petition is a genuine landowner. So inquiry
So
was
they have
conducted.
done an inquiry, they passed an order.
Yes.
It is submitted.
May I please,
Affidavit
Your
has also been filed by the condemned Lordship.
Yes.
Lordship, here, the court order dated 10/9/24 was already complied with before the contempt petition was filed, Your Lordship.
You did not inform him, did you inform him?
Yes.
You should have done it on day one when the notice was issued, you should have come and said it's complied. No notice. But now that you have complied with it, you have brought on record the compliance report.
Yes, Your Lordship.
We'll close it.
Yes, Your Lordship.
Compliance order I can do no only after filing this affidavit.
No
by
issues.
the
No
Lordship.
issues. That will not be. Learned counsel for the respondents, you give the names also. So-and-so appearing for, so-and-so learned counsel appearing for the respondents has referred to the affidavit in opposition filed on behalf of the,
Contemners, both the contemners, 1 and 2.
we have the respondent number 1 and 2, and has drawn our attention to the inquiry report of an inquiry held pursuant to the orders passed in WPC 117 of 2023, full stop. Learned counsel for the petitioner submits that the orders of the court has been substantially complied with, and therefore the contempt petition may be closed. In view of the above, this contempt petition stands closed on compliance.
Much obliged, Your Lordship.
Yes.
Item number 8.
Item number 8, bail application. Yes.
May I bless Lordship?
Yes.
My lord, on the last occasion, the Honorable Court has directed the learned PP to produce the case diary.
Yes, that were the records of the PI court and the documents produced by you were not in consonance.
I have the document from court record.
Yes,
Where
certified
no
copy.
coronavirus.
So whether the PI code has come or not, because
PI court record has come. Scan copies have come. See.
this is a CD, Lordship.
We'll look into it also. Seven to 44. Let us see this.
Lordship,
Yes.
As per the CD, the arrest warrant should have been sent on 27/6/2025.
27.
And I was arrested on 26/6.
Yes, on that day.
You were arrested on
26/6.
2025.
Yes.
Your name is?
Likau
Oh,
Tongoy.
I'm looking at someone else. I was looking at the other persons who was arrested on.
Actually, on hearing the news that there was a case against me, so I personally went to police station to clarify.
That is what you have gone through. you are not Tulu Vizimo.
Likau Tongoy,
Tulu Vizimo.
accused 3.
Yes, I'm trying to find out. Akoto Aomi. This is 7/6, 24/6. Yes, Likau
Tongoy.
Tungoy, na?
Yes, my lord.
Which is the format that you had said was given to you?
In my case, the format was under Article 22, Clause 1 of the Constitution of India, read with 47 CRPs, BNS. Whereas in the case of other accused 1 and 2, it is the information ground was only under Section 47 BNSS. So for the same case within 1 month, they have used 2 formats to inform the grounds of arrest to the accused persons.
Your Lordship, I received one document. It is a circular.
Show us.
As per this circular only, Your Lordship, the format was being given, and this circular was as per the direction of the Supreme Court guidelines, and as such, like this format is being used now. This is
Okay, the format used is okay. We are just trying to find out.
They don't need the exam. 16 May. So that is what it should be same. Because we all were in Juno. It should be same format. Correct.
Yes, how can I, this copy, it appears, was not given to you.
Why? My
I'm
lord,
not able to find out this page.
when we apply certified true
Yes,
copy,
yes,
not only certified copy, certified true copy through the district session judge. My lord, this is the certified, we applied through that. We got all the required documents, certified true copy. Then at that point of time, the ground of arrest was not there. So after that, planted by someone, not by her, not by
that is
her.
not. I think that will not be.
Record speaks. My application, look at the application. How I had, on which date my lord, through proportional, I applied on 24/7/25 through district session court. On the body of my application,
You're showing this, can you remove the picture? You see,
This is the CD also. The CD.
it is there.
The CD is also.
Show him this page also. That is one page after the forwarding report. Just look at the, sir.
no, that's what I'm saying.
One page before that page which I had given you in that file.
Yes, my lord.
One page before is the request for, is the forwarding report, right?
Yes.
Then here on the next page, it is something else. And there on the next page is something.
Yes. So I have been making a consistent submission that this is a total manipulation. So sorry, this one. I applied on 24 July 25
You're
to furnish
consistent.
all necessary documents.
One difficulty I had seen in your this thing, one thing I have noticed is that when you move the bail petition in the principal district and session judge,
Correct, madam.
you did not take this ground.
No, I took it because unfortunate that if the application is available on record, I took that ground. But unfortunately, the
Not
Nagaland
considered.
district judge had not reflected. Otherwise, that was the only ground I took in the district court also.
Give me that.
Application will prove.
Give me that. This thing.
My lord, in fact, this is my copy which I filed before district court. That was the specific plea.
Now, since it is on record,
Stand up and see. My lord, in my bail application
your
before-
CD, can I see that CD? Show me the CD.
In fact, I have made this consistently, even before district court, the same ground. Even today, even before CGM also. I am not keeping anything hiding. I'm not trying to shield.
This other person, Hukoto Zimo, has been traced. One of your colleagues has been traced.
There's still one more absconding. I mean, they're trying to trace you. Hukoto Yolochip from the Nasi.
And we were looking at this. Where is your petition? Where is your petition here?
Bail application before the district court.
Yes, yes.
I have my copy here. Paragraph 10. I have spoken. That is the only low point I have raised before district court also, my lord. Paragraph 10. I am very consistent on that point because that is a clear violation of Article 22 of the Constitution of India. Paragraph 10, my lord. Unfortunately, the district court failed to record that.
Okay. Keep this.
So therefore, in my respectful submission, on 27 June, when I applied for certified copy of all the documents available on case record, they gave me on that time when they gave me certified copy. Ground of arrest was never there. It was never formulated. Therefore, it was not there. It was not supplied to us. Therefore, my lord will appreciate, since I have given the original copy, certified copy, I have placed before the court on the earlier occasion. That is.
But you have already signed it here. Did you give a date? 67.
For the
As per the CD, Your Lordship, I have not seen the scan copy, Your Lordship, but as per the CD, the IO has already sent on 27th. So whether it is getting tallied with the,
No, on 26th, they have said that this information is given to him on 26th.
sending to the PI court, Your Lordship. That day is on 27th. So whether the record
Accused
is.
forwarding with a prayer for 72 hours
Yes.
police remand is on 27th. There
Yes, yes, that is the day,
there is no-
all the arrest form has also been sent, Your Lordship.
27 June.
27th is what is it?
I applied CT certified true copy in July, 24th July. On that day, they gave all the relevant documents available on record through certified copy.
My,
That time, the notice on information of ground of arrest was not available, therefore I was not provided. So now, whatever document they have produced today is nothing but planted.
Your
But
Lordship-
I'm not blaming anybody, but
Your
planted.
Lordship, with due respect to my senior counsel, Your Lordship, mere allegation cannot be made like that, Your Lordship.
That is
Should
my
be proof
submission. That
evidence.
is my submission.
There are some few things which are disturbing us. I will tell you what is disturbing us. Is that in his, where is that certified copy bunch? You have the certificate?
Lordship, I have
Yes,
given
it is
Lordship
here, it is
with the
here, it is
report. That's set, what I received, set.
It is what I'm saying. This
all
certified
set.
copy bunch,
Yes.
it does not contain any page numbers.
I have not changed anything.
But this record which has come, it is completely paging.
Afterthought.
That we don't know,
is-
Your
it
Lordship.
is-
That's
it is
why,
a-
Your Lordship, in order to create transparency, Your Lordship, I have.
No, I understand.
Yeah,
What I am trying to do is trying to find out whether
Yes, Your Lordship.
there can be a presumption that he was not informed about the grounds of arrest
Yes, Your Lordship.
at the time of his arrest.
Correct.
And maybe later on he was informed.
Maybe.
I'm not saying that,
Yes, Your Lordship, but yesterday also, as I have already submitted this circular, Your Lordship, there's already a specification. Now grounds has to be taken, Your Lordship, it has to be written.
There are
Now, that's why all the police stations are making sure to abide with this.
there are 4 pages here.
Yes, Your Lordship.
No, I will say 1, 2, and 3 pages here. The format for information
Yes.
is photograph and the medical, prayer for medical examination is medical examination report. These are not here in this bunch.
File has been properly arranged subsequently,
That is.
anticipating that this may land up in court.
We will not go to that extent, sir.
We don't know, anything
We
can
will not
happen
go to
under the
that
sun.
extent.
It might be either way also, we don't know.
We will not go to
It
that
is-
extent.
My lord, may I show one small.
It's up to the conscience of the court.
This is,
What is-
I have prepared just to show the veracity, just to help the court to know the truth. My lord, veracity of handwritings and using different name of the arresting official in the format of ground of arrest. 1. For the same police case, 2 different formats of information of ground of arrest have been used by the arresting official. The contents of the 2 different formats are totally different from each other. In case of accused 1 and 2, notices under section 47 of BNS 2023, whereas in the case of accused 3, it's me, and accused 4, notice of information is under article 22 clause 1 of the Constitution of India, read with section 47 of BNS 22. So total different, contents also different, format also different, in spite of the circular from Delhi. Number 2, the informations of ground of arrest in respect of accused 1, Akato Awomi, accused 2, Tulovi Jimo, and accused 3 is me. The name of the arresting officer is UBSI Mezavito Angami. Interesting below. 3. The information of grounds of arrest of accused 4, Mugaka Aye. The name of the arresting officer is UBSI Mezavito Aye. Instead of he himself had, it is claimed that the arresting officer has written the details look at the conduct of the arresting officer. 4. The numerical font style in all the informational ground of arrest are different. Lordship will see if you read ABC 1 to 3 letter, everything is different. Handwriting. 5. Handwriting in all the information ground of arrest appear to be different. 6. The handwriting entering the particulars of the arresting officer appear to be different in all the cases.
So we will not go into such a roving inquiry into.
Then, my lord, below that, as I have said, 7. The counsel for accused 3 submitted an application dated 24/7/25 to the district and session judge Dimapur requesting to furnish the certified true copy of all the documents relating GR 281 of 25. Sorry. On the same day, the learned district and session judge Dimapur has allowed the application written as court issued on the body of the application. 8. On the same day, that is 24/7/25, the certified true copy of all the relevant documents available in court's records except the grounds of arrest in respect of accused 3, it's me, had been furnished to the engaged advocate Grace Gauhati. So therefore, it's a clear case that at the time of arrest, ground of arrest was never formulated by the arresting officer, number 1. Number 2, ground of arrest was never communicated to me. These are the 2 things, my lord, apart from factual things, my lord. So therefore, when the documents have been supplied to me by way of certified true copy, and at that point, when the ground of arrest was not furnished to me, for the moment, it is presumed that it was not existing at that time. It was planted subsequently. This is my consistent submission. So therefore, it is a clear violation of Article 22, Clause 1 of the Constitution of India. And for that, Lordship, last time I have furnished a judgment just passed by Justice Devasis Barua, referred to
That
Supreme Court.
judgment will come to your aid in case we agree that you were not furnished with.
Absolutely, my lord, absolutely. And now, in the present case, it is established beyond doubt that at the time of applying for certificate copy, I was already in jail on 26 June. I applied on 24/7 July, next month. So in July, when I applied, the document furnished to me are all certified copy original, which I have placed before the Lordship for necessary for perusal and consideration. So therefore, all this shows that the ground of arrest was never formulated by the IO before arrest. Even after arrest, ground of arrest was not communicated or informed to me. So therefore, in the absence of this, the judgment passed by Justice Devasis Barua come to rescue me, because this is a similar case, my lord. So
We'll see about it. Yes, madam.
Yes, Your Lordship.
Why is further custody required? Tell us.
Your Lordship, the thing is that the accused now, as
My
far
lord, he has
as the
been-
grounds of arrest is concerned, Your Lordship, if it's there is a gray area there, then I'll leave it to your jurisdiction, because I have not even gone through the scan copy. It's directly here. So
You can go through, there's no difficulty.
yes, so Your Lordship, if this Lordship is of the
Whatever
opinion
this-
that there's a gray area, then I'll leave it to your Lordship, Your Lord.
This. And you also take this was your certified copies that you
My
kept. You also
original,
take,
given
you
by
also-
court.
You also take a look at this, madam.
You can check. That time, Lordship has rightly pointed out, that time it was not even paginated. Now carefully paginated. We have observed yesterday.
Sometimes that lawyer inside me tries to come out. And I have to really fight to keep him down.
My lord, my lord.
We'll have it after some time. Let madam go through it.
My-
Let madam go through it. And you also formulate why the continued detention is required.
Your Lordship, besides leaving aside the arrest grounds of arrest, Your Lordship, our contention is that, Your Lordship, the gun, Your Lordship, the instrument which has been used during the abduction, Your Lordship, that is also not recovered yet, because it seems that it belongs to the present accused. But the present accused is denying, and he is the green card holder, Your Lordship, entitled to have a bodyguard with a gun, Your Lordship. but now here is
So what,
denying that.
your bodyguard still carries the gun?
Your Lordship, he is a green card holder, Your Lordship. Green card holder are
That concept I
entitled.
do not know, you have to
Yes,
explain. What is
I
it?
think,
I'll explain.
yeah. So besides that, there's still one absconding, and they're from same cadre, Your Lordship, and therefore the IU deems it that like,
He should be released as
yes,
of.
yeah.
What is
That-
the
that
green
is-
card holder?
Lordship will ship it. Nagas. There is a ceasefire between the Naga underground and Indian government. Talk is going on. According to the news, immediately after 15 August, talk will resume. So I am one of the high-ranking underground wala.
Okay.
So having ceasefire, and therefore it is no more a banned organization. Green card means government of India through Home Minister D.K. Mishra has allowed officials to carry 1-2 small weapons
For your own
on
safety.
safety, because a lot of factions are there.
But that
So
doesn't
for
mean
safety.
that illegal
Now
activities has
therefore,
to be
anyway, that will come
When
at
we say it is for safety, we should also say it is not for livelihood.
no. That will come at the time of trial, no doubt about it. I'll prove that that was no mission. That part is
That was just a.
yeah, for education. Much of that.
We'll have it after some time. You go through the documents.
No problem. Let her go through, no problem.
Because we are just trying to find out. See, if he, whether he is a man who was arrested, which is one part. That he should have been told his rights is another part.
Definitely.
What I am just disturbed by is if someone had made a mistake, did not inform the grounds as required under law, then the law has to take its course.
Definitely.
He may be,
Definitely, Your
there may be so many other reasons to put him behind or to keep him in custody. But if there is an attempt, then I am not going to pass any judicial orders as of now saying that this was wrong and that was there is a manipulation. I am not going to do that to that extent without having an inquiry. But if it is reflected somewhere there, then things have to be corrected. People have to be able to trust the law enforcing agencies.
That's what.
As well as the person, as
That's
well,
true, that's
all angles have to be taken into account.
Your Lordship, the CD may also be given.
we look up to the court.
Huh?
That CD.
CD
so
also,
that
you
we'll
see
just
for the
check.
We look up to the court, district court, we look up to the police, law enforcement, so we have trust.
Because he is a person who apparently had surrendered.
I went.
There was no requirement of chasing him around.
No.
We have to keep that also in mind.
Yes, Your Lordship.
His consistent statement that I have not been told. That part we have to keep in mind. The presence of those documents in the records now, but not supplied to him with the certified copies is also what we have to keep in mind. So without going into, we will not try to conjure up what might have happened, but we will try to find out, at least someone should somewhere understand that this is not to be done, if it has been done. And if it has not been done, it better not be done.
Yes, Your Lordship.
Yes, next.
Item number 9.
Contempt. Yes, someone was asking for time in the morning in this contempt. Who was asking?
Please, Your Lordship, I'm mentioning on behalf of my colleague in Holi. Your Lordship, I'm informed that she is yet to receive instruction, so another 3 weeks will be granted for her.
When was the order passed?
Your Lordship, it's in Annex 1, page number 10.
What is the date of their order?
Your Lordship,
February
17
2022.
February.
17 February, asking what? You are only required to take a decision. Respondents are required to take a decision.
Yes, ma'am.
Minutely examine the case of the petitioners, take a decision as to whether the petitioners are discharging the same nature of work. Minimum scale of a witness period of 60 days. So this was passed on February, March, April. Yes, what is the stage of compliance? See, this submission that instructions are not coming, if councils cannot get the instructions, then this court can get the instructions.
No, Your Lordship, my apology, Your Lordship, I just came to know that the matter belongs to my colleague.
I understand.
So
There was
she's
some mention in the
indisposed.
morning. Someone mentioned it in the morning. Who?
Motion in, for Miss Inaholi.
In
On behalf of
No, someone mentioned it. Someone.
Yes, ma'am.
Ask the council to be here. Can we ask the council to be here? I told him that we'll take up the contempt matter as and when it arrives. Why is he not in court?
Your Lordship, then if the main counsel is indisposed, so maybe defer to Monday or maybe Thursday, so that like we can, since we were not well briefed with the case. So.
Notice in this contempt petition was issued on 10/6/2025. And on 28/7/2025, appearance was entered on behalf of all the respondents, comma, when the learned counsel for the respondents prayed for 3 weeks' time to receive instructions and to file counter affidavit, full stop. By the order of which disobedience is being alleged, comma, the respondents were required to examine the case of the petitioner and take a decision as to whether the petitioners are discharging the same nature of work, duty, and responsibility as discharged by regular grade 4 employees within a period of 60 days from the date of passing of the order. Today, a prayer is again made on behalf of the learned counsel for the respondents that instructions are awaited from the respondents, and therefore a prayer is made that the matter may be taken up after a week. Let this matter be listed after 1 week on. Yes, give me some date. On so and so date. By which time? On which day? The learned counsel for the respondents shall place necessary compliance report before this court. Full stop. It is made clear that in the absence of instructions and or affidavit on behalf of the respondents on the next date fixed, necessary orders will be passed. Full stop. List the matter on, just give me a date.
28
28th of?
this month.
We'll give them 1 day, 1-2 days more. Make it on the 2nd of September.
Yes, ma'am. Yes.
See, contempt matters, this is not even for payment.
Yes,
This is for
appreciate.
holding an inquiry,
Appreciate.
taking a decision.
Yes, yes. Much obliged.
Item number 12.
Yes. After some time, call it after some time. Call it after some time.
item 1, 2 and 3.
What is 2 and 3? Where is that appeal?
May it please, Lord. My Lord, this IA is filed for production of additional evidence, filed under Order 41, Rule 27, read with Section 107 and read with Section 151 of CPC. My Lord, here, for the first time, the appellant, it is the respondent, they have raised this issue in the appeal, saying that the vehicle which met accident was not in possession of road permit. So, my Lord,
LCR we call for, received? Huh? LCR received? Okay.
my Lord, the implication that has been made in the appeal memo, it was for the first time, my Lord. And pertaining to this issue, in the trial court, issues has not also been framed. My Lord, only after receiving the copy of the appeal memo by the applicant, this...
You are the claimant?
No, I am the vehicle owner.
Vehicle.
Yes.
Yes.
So, my Lord, since this issue was raised in the appeal, only by receiving the copy of the appeal memo, the applicant could understand that the question of the road permit, which was in their possession at the time of accident, that was surrendered before the transport authority for renewal of the road permit. So the subsequent renewal of the road permit was filed in the trial court, in the trial stage. And that was valid with effect from after the accident. So, my Lord, during the trial stage, this issue never came up. So, even the counsel who were appearing for the vehicle owner, they also not apprised about the requirement of this document. However, since this issue has been raised in the appeal, the applicant made effort to locate the document, but only the Xerox copy of the document could be located. And after locating that document, this application has been filed to allow the applicant to place this additional document as additional evidence of the court.
Appeal has been filed by the insurance company.
Yes, Lordship.
Now, in a tussle between the insurance company and the owner, where is the claimant?
Claimant here.
Yes. Received any amount or not?
50% of the awarded amount.
You have received 50%. What was the awarded amount? How much was awarded? What was the injury? What kind of an injury did you suffer?
Your Lordship, there are two claimants. So one person is a left femur fracture, and another claimant is a facial bone fracture. So sustaining 40% disability, permanent disability, and 45% permanent disability.
One has been awarded 15 lakhs, one has been awarded 14 and a half, 14 lakhs, 24,000. Okay. You are not aggrieved by the amount of compensation?
We are also aggrieved by the amount of compensation, Your Lordship, because the disability is just physical disability. The loss of income it was not considered by that tribunal. I have taken one ground on that also. And one of the ground is that the route permit. This issue was
Now, if the road permit is not there,
yes, sir.
then what is the consequence?
There
No
will be
compensation.
breach of policy. Your worship. So the insurance company will not be liable to indemnify the.
So you will claim
vehicle
from
owner.
him, you'll claim back from the owner of the driver. Can you shirk your responsibility to pay the claimant?
We have already deposited that one. We are not denying that one.
You have deposited 50%.
50% of the.
And you will deposit the rest also to them, and
If the
you
court
will
finds-
recover whatever you have from the owner or the driver.
Yes, that ground is there.
Now you want to shirk your responsibilities by saying that we
My-
had a photocopy.
Lordship, my contention is that during the time of accident, the vehicle was in possession of valid road permit, though it was not filed in the trial.
That will be one of your grounds to rebut any claim by him to recover the money from you. At this stage, why?
Lordship,
Will you recover from him under orders of this court?
yes, Lordship.
Can I order that you recover whatever you have from him? No, you'll pursue your own remedies.
Yes.
Not in an appeal.
Not in.
If I understand correctly.
Yes, sir.
Correct me if I'm wrong. I'm open to.
Not in this. Yes, Lordship.
So even if your eye is allowed, nothing much happens.
My lord, as per.
It is not your appeal.
No, yes, not my appeal. Not my.
So that is number one.
Yes.
Number two, he cannot claim any recovery from you in this appeal. I don't think this is the proper forum. You will have your own methods of recovering it from him, filing a suit, whatever. There you will rebut and do whatever you have to do.
But my lord, one aspect is that since this document was not, road permit was not this thing produced before
It's a
the trial court.
photocopy.
My lord.
What you now have is a photocopy.
My lord.
How can I allow a
But my lord,
photocopy to be taken out?
here, the question is that I can leave evidence by producing witness if this is permitted in if the matter is remanded back to the tribunal. Because the issue with regard to document has also not been framed. Your Lordship may kindly see at page 15 of my petition.
IA.
Yes.
IA which, what is the
IA
number?
198.
198.
My lord, at page 15 of
Page?
page 15 of my petition.
Page 15 is the award.
Yes, that is the.
Whether accident took
Yes,
place, whether
at
claimants were traveling.
Para 8. Para 8. My lord?
Yes. 22 years old, traveling in passengers, yes. You did not take up this ground.
Your Lordship,
That it is not
raised
insured.
here, but the issue was not. It was not an issue here.
Where did you raise that ground? Show
in
me.
my written statement.
What did you say? Where is your written statement?
In my written
Sir, please take your seat. Take your seat. Since we are hearing the appeal and the IA both, let me understand the appeal also. Yes. Take your seat, sir.
Your Lordship, before that, Your Lordship.
No, your written statement first.
Yes, okay. In my written statement at paragraph 4,
Page.
in my IA, Your Lordship, in my, sorry, Your
Appeal.
Lordship, this one, affidavit of opposition. In para 8.
No, in your appeal,
Yes.
you gave your written statement as a document.
Uh,
Have you annexed it?
no, Your Lordship.
You have not annexed a written statement.
It was not annexed, Your Lordship. Only the route permit and this one, order, Your Lordship. But in my affidavit of opposition,
Filed in
against this IA
198.
Yes.
What is 199 about?
Same issue, Your Lordship.
Same issue.
Two.
Yes.
Yes.
That was through appeal.
Yes, you show
In
me your
para-
affidavit of position. Where is it?
Just one statement, Your Lordship, in para 8, which page number
What
3,
kind
Your
of
Lordship.
filing is
para-
this? There's no page number, nothing. Where is the page number? Huh? Filing has been very good. Switch this off. Para?
Para 8, Your Worship.
8.
Yes, a statement has been made, Your Worship.
Where is your written statement? I'll have to then you find it out from the LCR. Show me. These are small documents you can keep annexed. Acha, the judgment, does it say anywhere that you had taken this ground?
No, Your Worship.
You were the OP number?
OP number 3.
3.
Yes.
Compensation claimed is without any basis, accident involving so and so. A portion.
Your Worship, it may be mentioned here that this document was exhibited as Exhibit 9, Your Worship.
This one? This one, this one.
Exhibit 9.
Exhibit 9. You
Yes.
give me the LCR. Give me the LCR.
Exhibit D9. So,
D9.
yes, so this was already placed before the tribunal, Your Worship. And now they are placing another new document before this court at the appellate stage. That's why we have filed our objection, Your Worship. And if from the petition, Your Worship, annexure B and C, if we see, there is a discrepancy also about the date. So at this belated stage, allowing this.
You are saying that the road permit was not there?
Yes, Your Worship. It was not valid. The new one, the latest one, which was also placed.
So far as we are concerned, you did not raise any objection in the trial.
Trial.
You were represented.
Yes, Your Worship.
You did not take this objection then.
That
You
was-
filed in your written statement, I find in the order, you had also sought for leave to take up all the grounds.
Yes, Your Worship.
But you did not take up the grounds, you did not press that prayer.
Yes.
So now, should we allow you to take up all these grounds before us when we have nothing to say whether you recover it from them or not?
Yes.
Because has the tribunal come to a finding that they had a valid road permit? Has it come to a finding anywhere in the judgment?
No, Your Worship.
It has not been said so.
No. It's-
So since it has not been determined by the tribunal,
Yes, Your Worship.
you can always take up that ground. And whether he had a road permit or not at that point of time is what he will contest when you may raise the claim to recover from him. Why should this appeal be entertained on that ground? You tell me that.
There are other grounds, Your Worship.
We'll come to the
Yes,
other
yes.
ground, but this ground that he did not have a road permit and therefore you should not be liable. That is settled law, that is between you and him. That is not in an MSC appeal. You will ultimately file a suit or something against him, you will raise a demand that you did not have a road permit, therefore as per the settled law, please pay us whatever we have paid them. That is what he will do.
Yes.
It is then he will object and say that I had a road permit. Then that will be contested.
Yes. But allowing this at this stage may create a problem, Your Worship, because the document out here.
No, I am not allowing, I may not be allowing his application to bring that thing on record.
Okay, Your Worship.
Because you are only saying you have recovered a photostat copy. How can I allow a photostat copy to be made a part of the evidence? By what law?
My lord,
You cannot even exhibit a photocopy.
yes, my lord, here there is a decision of the appeals court.
Yes.
Where if such a situation is there, then it can be remanded back to the tribunal, allowing the other party also to ask to adduce evidence. And
No, even if the remand is there, it will be only to decide whether there was a valid road permit or not.
Yes.
But the compensation part and all that, the claimant is not suffering on that.
No, my lord, that I understand.
Claimant will not suffer. Your and his
My
fight,
lord,
claimant cannot suffer. Submit a judgment.
My lord, one is 2022 7 SEC, page 247, Sanjeev Kumar.
You have the list of books he's showing?
My lord, at para 7 and 8. It is at page 249. It is true that the general principle is that the appellate court should not travel outside the court of the lower court and cannot take any evidence in appeal. However, as an exception, Order 41 Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. It may also be true that the appellate court may permit additional evidence if the conditions laid down in this rule are found to exist and the parties are not entitled as of right to the admission of such evidence. However, at the same time, where additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit and interest of justice, clearly renders it imperative that it may be allowed to be permitted on record. Such application may be allowed.
What is the main issue in this case?
My lord, here, since they have raised this issue with regard to road permit.
The main issue, let us read it again. It is true that the appellate court may permit additional evidence
My lord.
if the conditions laid down in this rule are found to exist and the parties are not entitled as of right to the admission of such. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit. What is the main issue in the suit? Whether there was an accident, whether he's entitled to compensation or not.
The question now is that in the appeal, in the present appeal, they have raised this issue, not in the trial stage. Now, this issue has become it has become a new plea.
So you seek a dismissal of the appeal.
So, my lord, but however, by way of abundant questions, I have come before this court by this application for allowing to adduce additional evidence, my lord.
Yes, any other judgment?
My lord, the other judgment is 2019, volume 12, SEC, page 366.
366. What does it say? On the same lines.
My lord. Here, para 5 to 8. My lord, here, which is at page 368. We find that the courts below have dismissed the application of the appellant under Order 41 Rule 27 CPC and refused to take the aforesaid document on record on the ground that the same is irrelevant for fixation of the quantum of standard rent. That may not be correct. In any case, it can be examined at the stage of trial. At this stage, some document is produced and we find that these documents may have a bearing relevant for deciding the controversy between the parties, and all the requisite of Order 41, Rule 27, CPC stands satisfied in as much as this document was not in possession of the appellant at the time of trial of the petition and came to the notice of the appellant at the stage of pendency of the revision petition.
These are all cases.
The Federal Counsel for Respondent has argued that the authenticity of this document is not established. Again, that would be a matter which will have to be examined during the trial.
Yes, that is.
We thus, my lord, next para, we thus allow this appeal and set aside the order of the court below as well as application filed by the appellant under order so and so stands allowed. Needless to mention that the respondent shall also be given an opportunity to lead the evidence in rebuttal.
No, you first make me clear on one point. the award has been made,
My lord.
it will be satisfied by the insurer.
My lord.
And in case the insurer takes a plea that it is not supposed to be liable under the act, then they will recover it from you.
My lord.
That is
My
the
lord.
whole situation.
My lord.
Insurer cannot come in appeal to say that I should be allowed to recover from him.
My lord.
Why should we allow such? These are not issues that this court will decide whether he can recover or not in an appeal.
Your Worship, one of my submissions.
Uh-huh.
It's the duty of the vehicle owner also before the tribunal to place that his vehicle was plying with all the valid documents. His due diligence was not made here. As I have already said, he has already exhibited this document, one of the document, route permit, before the tribunal, which clearly shows that
Was not for the period.
yes,
Was
the vehicle
not
was
for
not-
the period for when the
When
vehicle
the-
had already undergone the accident.
yes, Raj. And it was not constituted by the learned.
It was not considered by the Learned Tribunal
Learned
because it
Tribunal.
was not raised by you.
We have made, it seems we have made some submissions.
No,
during the-
yes, that is what I wanted to see
Yes, Raj.
in the WS.
Yes.
Where is the WS? You are respondent, you were opposite party number?
3.
Number 3.
3. क्या मिलेगा ये? You don't even give it. P number.
Written statement, para number 10.
I'm trying to find out where is your written statement. We are Muni Devi.
Oh, no, it's para number 10.
Written statement on behalf of
OP3. Oh, number
3. Yes, what did
One
you
of
say in
the
para 10?
paragraph number, I'm not having the copy with me, Your Worship, but one preliminary
try to
objection we have raised, Your Worship. In the preliminary objection, we have categorically stated that
At paragraph?
the vehicle was plying without relevant documents.
Preliminary objection.
Yes, Your Worship.
Claim is devoid of material, compensation is without legal, not maintainable, relevant document pertaining to the truck, no right to claim, not furnished any evidence, lack of knowledge, no comment, conjecture, no comment, strict proof, no comment, far-fetched. Yes, I marked it for you. Show me where you took that stand. Show me. This is what the appeal is. Yes. Is it there?
Page 2, paragraph 4, Your Worship. That's
Missed it.
the vehicle was not plying with relevant documents, Your Worship.
You were saying that the claimant has failed to furnish the relevant document.
Yes, Your Worship.
Where from the
It's
claimant
the
will bring
duty
it?
of, it's the honest duty of this one to
But
prove that
you are-
he was plying. Your
You
Worship.
contested the claim.
That's why we have.
The pressure, the claim was tried to be contested. You did not contest his papers anyway, did you? No. You did not raise this question. You must be thinking, why should I raise that question? Only the claim will not do. Yes, in your grounds, where is that?
In my
Appeal ground, where is your ground?
appeal,
Was it merely an argument or?
ground number 4, Your Worship.
For the tribunal could not appreciate the terms of policy issued to the insured subject to certain terms and conditions which are the essence of the contract.
Yes, Your Worship. 5 also. The liability contractual obligations, breach of any condition.
Even if the breach was noticed by the tribunal, would there be any difference in the conclusions that it arrived at?
My liability won't be due, Your Worship. I will have to pay
You
and
will
recover.
recover. So
Yes.
that remains even if we now allow your appeal, that part remains.
Yes.
You pay him the full.
Yes, Your Worship.
Okay, now tell me the other part. What are your other grounds?
The other ground is that one is my first ground, maintainability, Your Worship. That the vehicle was not driven rash and negligently, Your Worship. Because there's only one GB.
That leave
Yes, Your Worship.
was not granted to you by the tribunal to take that ground. That is a ground which can be taken by the owner or the driver.
Lordship, the issue was not settled.
I'm not on there.
Yes.
Under 170, and that other case, I'm forgetting the name, Nicoletta. Should be Nicoletta Rotagi. You can only take up grounds when you take the leave of the tribunal. 2002 judgment, sir. Is it 2002, the judgment?
In
Nicoletta?
SCC, it is 2002 volume 7.
Yes?
But
Yes, see.
TSC, it is volume 3.
SCC, it is volume 2, no? Nicoletta Rotagi, that the insurer cannot take up the grounds to register claim unless you take leave. That leave was not taken, so grounds which are available to the owner and the driver. I was not negligent, I was driving carefully, he was drunk, all those things cannot be taken up by the insurer unless you take leave. Leave will be granted to you on 2 grounds. One, the claimant and the the owner of the driver, they are acting in collusion to make money out of it. Or the owner and the driver fail to contest the claim as they should contest. Am I correct? That is what was laid down. And if that leave is not taken in the tribunal, you will not be allowed to take those grounds in appeal. If I am correct. You can try and convince me otherwise also, no problem. I am open to any argument. So your ground that it was not being driven rash and negligently, it goes. We will not allow you to take that up.
Then I'll come to the quantum. Quantum also.
Quantum, okay. That we can listen to you because that is given only at the time of the award. You cannot take leave to defend it earlier. Yes. On the quantum. What is wrong?
Just a moment, Your Worship. In my petition, Your Worship, page number 36.
36?
Yes.
Yes.
The issue number F. Whether the claimants are entitled to compensation. If so, to what extent and payable by whom? Here, Your Worship, if I may read, Your Worship, all the issues A, B, C, D, E, and F stands duly proved and decided in favor of the claimant. As such, the claimants are entitled to compensation for the injuries sustained by them and for the loss of future earning capacity. The injured claimants were 22 and 25 of age at the time of accident. As such, the relevant multiplier is 18. The claimant definitely had a promising career in Reshma so. The Supreme Court has thus held that the just compensation, adequate compensation, which is fair and equitable on the facts and circumstances of the case to make good the loss suffered as a result of the wrong as far as money can do so by applying the well-settled principle relating to award of the compensation. It is not intended to be a bonanza, argosy, or source of profit. Taking into account the educational qualification of the claimant and present rate of wages, remuneration, and notional income of the injured claimant is taken as 10,000 per month. The extent of permanent disability, Your Lordship, according to the disability certificate issued by the medical board, is 45 and 40% respectively in MSc number 84 and 85, according to the compensation to which the claimants are entitled as per so and so.
You simply multiplied it.
Yes. Here, Lordship, I would like to please
Rajiv Arora.
Rajkumar.
Rajkumar versus
Ajay Kumar and Haran.
Yes, sir. What do you say about Rajkumar, Ajay Kumar?
Your Lordship,
I'm trying to cut this short, as short as possible, so that.
Your Lordship, my submission is will be brief, and besides other objection, raise challenge questioning the quantum of award and merit of the case. The appellant cannot raise such question without taking permission from the tribunal under section 170. So he cannot raise such questions.
Which
And
question?
this, in terms of Nicolata's judgment.
No. What I am trying to understand from you is this. The quantum of compensation has been decided by the tribunal by saying that the medical certificate says 40% disability, and therefore I will go by 40%.
Yes.
Rajkumar says that medical certificate may say 40%, but what the court is to find out is what is the extent of loss of income because of that 40% disability. Some person, if he loses, suppose he loses his, God forbid, his left hand in an accident, and he is a singer by profession, then his disability would be 50%. But the loss of income due to the loss of hand would be 0. You would be a singer, you would be earning still. Then again, if we look at the example given in that Rajkumar and Ajay Kumar, that if a man is a chartered accountant, that was the example given in that case, some other case, chartered accountant. If he loses a leg, he will not be able to go and appear in courts, he will be not able to go and appear in tribunals. So definitely he will lose more income than that 30 or 40% given in the disability certificate. So the that percentage for loss of income has to go up. In your case, court has said, a tribunal has said, disability 40%, therefore multiply by 40%. There is no evaluation that because of the facial fractures, you lost income, or you will not be able to make income. That consideration is not there.
Your Lordship, it is not my argument for that, but then my humble submission before this honorable court is that while assessing the compensation for the physical brokenness and shatter of the physical frame, this while computing the compensation, it should not be only confined to that particular limb or that particular injured part, but it should be considered as a whole of the physical body.
Exactly what I'm saying.
That's why
the judgment does not say so. This judgment
I would like to rely on this the judgment pronounced by the Honorable Supreme Court in SCC 2014, Volume 11, page 178. Party's name V. Mekala versus M. Melati and others.
Just a minute, sir. Just a minute. Just give me 1 minute. You have an extra copy, no?
I have copy.
Okay, I'll just try to find it.
It is there.
Is it? It is SCC?
SCC, Your Lordship.
SCC 2014.
Yes, Your Lordship. 2014. Volume 11.
14.
Page 178.
You have it? Page 148.
178.
178.
8. 178.
178, yes.
Your Lordship, paragraph 20 and 25. And Your Lordship, this Honorable Court, while passing this judgment, has relied on the judgment
Santoshi and Salah.
Relied on the judgment of R.D. Atar Gandhi, and it is stated at para 6 of this judgment, page 183.
Let me also update myself. Yes. You said para 20 and 25.
Your Lordship, for this judgment.
20, what is it? Therefore, in the light of the principles laid down in the aforesaid case, it would be just and proper to keeping in mind the past results. No, we are agreeing with you that the monthly notional income will be fixed. That is what is the in para 20.
Yes, Your Lordship.
I'm not on that. What I'm trying to find out is, if the disability certificate says the disability is 45%, should the tribunal only multiply it by 45%, the multiplier and the notional income, and then come to a finding? Or should the tribunal look into what is the extent of loss of income, loss of notional income, because of the disability being suffered by the claimant? You have that Ajay Kumar judgment?
Yes.
What is it, Rahul? No. Huh? Rajkumar versus Ajay Kumar, you have the judgment. Para 8, please read. Please read para 8. Was it para 8? I also keep forgetting now. Long time. What is the citation, Rajkumar?
2011.
Just a minute. It is SCC and 2011.
2011, volume 1.
Just a minute. 2011.
Page 343.
2011, volume 1.
Yes, Raj.
And?
Page 343.
343, okay. Yes, sir. Rajkumar, Ajay Kumar, okay. What does it say? That one part I was reading. Yes, please read para 8. para 8, where the claimant suffers. Can you read? Please, where the claimant suffers.
Para 8.
8, what is para 8?
Disability refers to any restriction, Worship.
The 2 paras thereafter.
Permanent disability performs. Disability refers to any restriction or lack of ability to perform.
No, para 10. Please read para 10. Please read para 10.
Where the claimant suffers a permanent disability as a result of injuries, the assessment of compensation under the head of loss of future earnings would depend upon the effect and impact of such permanent disability on his earning capacity. The tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss or loss of earning capacity.
Yes, this is what I'm saying.
Yes, Worship.
Yes, sir, the para 10 of the judgment. Ajay Kumar. Just because the disability in the certificate is 40%, it will not be the you cannot multiply the loss of income by 40%. There has to be some evaluation before we do that.
Yes, sir.
Your Lordship,
yes.
This, as per the judgment of
Which
the MSCT, which is under
Yes.
Appeal Memo, page 36.
36. Okay. Let us again read it. 36. Yes.
Appeal Memo, page 36. The learned member the learned member of a tribunal has arrived at this
Just 1 minute. This is correct. So that is correct. Please change the glass. Yes.
arrive at the conclusion that the claimants are young. So on this particular point raised by the appellant, it is decided by the tribunal. This in issue number D. And issue number D is page 35. It is a continuation of page 36.
Yes.
Issue number D, whether, may I please read out your
issue number?
Page 35, issue number D, as per judgment.
Yes, whether the claimant was 22
Whether the
years
claimant was 22 years old in MSc 8415 and a student, and whether the claimant in MSc 8515 was 25 years old and a student having bright future at the time of accident. Your Lordship, this I'll read out all. The claimant in MSc 84 2015 has exhibited his SCLC ethnic card as exhibit P15, wherein his date of birth is recorded as 2nd December 1991, proving that he was 22 years at the time of accident. So his SCLC mark sheet, his SSLC mark sheet, BA Sociology mark sheet, MSc Counseling Psychology first semester mark sheet, and certificate from the Martin Luther Christian University, Ceylon, certifying that Clement was a student of the university, are exhibited as exhibit P17, P18, P19, and P20, respectively. These educational documents are not disputed by any of the OPs. The claimant in MSc 85 of 2014, Your Lordship, here the year is wrongly written, it should be 15, has exhibited his student ID card issued by the National Institute of Open School as Exhibit P23, where his date of birth is recorded as 2nd January 1989, proving that he was 25 years at the time of accident. His educational documents are exhibited as exhibits P24, P25, and P26. The educational documents are not disputed. It is decided that the claimant was 22 years old in MSc 8415 and the claimant in MSc 8515 was 25 years old at the time of accident, and they were both students having a promising future. Your Lordship, and this judgment which I refer now is it is a similarly situated case that where in this case the claimant injured was a student of class 12.
What, which paragraph you have said, Mikala? V. Mikala, you are saying para 20.
20 and 25.
Two 2012 6 SCC 421. Can we have that book? 2012 6 SCC 421. Okay, anything else on that quantum part or the calculation part?
Your Lordship, this, in addition to my submission on the judgment of the MSCT, it is also required to look into issue number 5 decided by the learned member of MSCT.
5, that is issue E. F6, yes.
Whether the claimants are entitled to compensation, if so,
by
to
whom?
what extent and payable by whom? All issues number A, B, C, D, E, and F stands duly proved and decided in favor of the claimants. As such, the claimants are entitled to compensation for the injury sustained by them and for the loss of future earning capacity. The injured claimants were 22 and 25 years of age at the time of accident. As such, the relevant multiplier is 18. The claimant definitely had promising careers. in Resma Kumari and others versus Madan Mohan and another, 2013, Volume 9, SCC, page 65. The Supreme Court held thus, just compensation is adequate compensation which is fair and equitable on the facts and circumstances of the case to make good the loss suffered as a result of the wrong, as far as money can do so by applying the well-settled principles relating to award of compensation. It is not intended to be a bonanza, largesse, or source of profit. Taking into account the educational qualifications of the claimants and the present rate of wages, remunerations, the notional monthly income of the injured claimant is taken as 10,000 per month. The extent of permanent disability according to the disability certificate issued by the medical board is 45% and 40% respectively.
That is what I'm asking you again and again.
Yes.
The disability is 40% and 45% as per the certificate. That is the extent of disability of the person himself, total disability. Now, because of this disability, what percentage of income he has lost or he will lose? Where is that evaluation by the tribunal? Is what I'm trying to find out.
Your
The
Lordship,
tribunal has to say that he can earn 10,000 a month. Because of the disability, his income comes down by 30%, and therefore I will compensate that 30%. He cannot say that the disability is 90% and therefore I will give him 90%.
Your Lordship, in the same page as I have written at the readout, at page 37 of the judgment,
yes,
the learned tribunal has made a calculation. Though notional monthly income is taken 10,000,
yes,
but the compensation assessed is only as per the percentage of the disability. The tribunal has arrived in this.
I will try to understand it again. Can you come to the Rajkumar case, 2011? Para 11. Sir, will you be kind enough read it? Para 11.
What requires to be assessed by the tribunal is the effect of the permanent disability on the earning capacity of the injured. And after assessing the loss of earning capacity in terms of the percentage of the income, it has to be quantified in terms of money. To arrive at the future loss of earning, by applying the standard multiplier method used to determine loss of dependency, we may, however, note that in some cases on appreciation of the evidence and assessment, the tribunal may find that the percentage of loss of earning capacity as a result of permanent disability is approximately the same as the percentage of permanent disability in which case, of course, the tribunal will adopt the same percentage for determination of compensation.
12.
Yes.
Then para 12. Therefore, the tribunal
has to first decide whether there is any permanent disability, and if so, the extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence whether the disability is permanent or temporary. If the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. Number 3, if the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on the functioning of the entire body, that is the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of future earning capacity. If the tribunal concludes that there is a permanent disability, then it will proceed to ascertain its extent. After the tribunal ascertains the actual extent of permanent disability,
This is what I'm saying, sir.
of
That
the,
suppose we take that the man has, the claimant has suffered 40% disability medically. The tribunal has to see what is the effect of that disability on his earning capacity. That has not been discussed.
Your Lordship, if I may read para 16 also. Yes.
16.
The tribunal should not be a silent spectator when the medical evidence is tendered in regard to the injuries and their effects, in particular the extent of permanent disability. Section 168 and 169 of the Act makes it evident that the tribunal does not function as a neutral umpire in a civil suit, but as an active explorer and seeker of truth who is required to hold an inquiry into the claim for determining the just compensation. The tribunal should therefore take an active role to ascertain the true and correct position so that it can assess the just compensation. While dealing with personal injury cases, the tribunal should preferably equip itself with medical dictionary.
Yes, sir. We have seen the case.
Yes.
Yes, sir. Now tell me, what we propose to do is this.
Your Lordship, I rely on this judgment as well as Nicoletta.
Nicoletta is what I'm saying from so long. To say that appeal cannot be preferred.
Yes.
If leave is not taken. So I will not allow any ground which was not taken in the tribunal with leave to be taken up in this appeal.
Your Lordship.
That much I agree with you.
Yes.
But that substantial question of
para 32 of
yes,
this judgment.
That is what I am saying from the morning itself.
For the aforesaid reasons, our answer to the question is that even if the appeal is preferred under Section 173 of 1988 Act by an insured against the award of a tribunal, it is not permissible for an insurer to file an appeal questioning the quantum of compensation as well as findings as regards to negligence or contributory negligence of the offending vehicle. So all these are...
He is not challenging anything.
Yes.
Any of these factors he is not challenging.
Yes.
What he is challenging is, in one simple word, this, what is that case name? Arora, what? Rajkumar.
Yes, Your Lordship.
That Rajkumar has not been followed.
The learned tribunal in his wisdom has assessed this compensation.
I think it will have to go for a reassessment. He has not assessed as to what is the effect on the income. That is the main problem.
The disability certificate is not challenged.
Need not.
This is not challenged.
Even that is why they did
also
not take leave.
has not raised any issue on this disability certificate
Yes.
by the insurer.
Disability, if the certificate says 100, he is agreeing to it. If it says 0, he is agreeing to it.
So, Your Lordship, this in V. McCullough's judgment, the Honorable Supreme Court has arrived
which
on
judgment?
the conclusion that the para 20 and 25 and
V. McCullough.
rely on the judgment R.D. Hattagandhi. R.D. Hattagandhi. This in this judgment at para 6, page 183.
Page 186 also it is reflected.
The relevant para is reproduced in this judgment is para 10. It cannot be disputed that because of the accident, the appellant, who was an active practicing lawyer, has become paralytic on account of the injury sustained by him. It is really difficult in this background to assess the exact amount of compensation for the pain and agony suffered by the appellant and for having become a lifelong handicapped person. No amount of compensation can restore the physical frame of the appellant. That is why it has been said by courts that wherever any amount is determined as the compensation payable for any injury suffered during the accident, the object is to compensate such injury so far as money
can compensate.
Because it is impossible to equate the money with the human sufferings or personal deprivation. Money cannot renew a broken and shattered physical frame. And also, this relied on the judgment of K. Narasimha Murthy versus Oriental Insurance Co. Ltd. at para 18 of this judgment, page 187, and has reproduced the judgment of K. Narasimha Murthy, para 41. Further, it needs to be emphasized that it is not the right of the tortfeasor or a person who has taken over the liability of a tortfeasor in terms of and under the Act to detect the injured persons, to detect that the injured person should do some work, manual or otherwise. It does not matter what may be pain and discomfort in order to minimize his or its liability. Such insistence is untenable in law, and if such is the case, it would violate the basic human rights of the injured person. In this case, the appellant is reduced to such a state that he is unable to do any work, manual or otherwise, without subjecting himself to pain and suffering, agony and discomfort. Your Lordship, these human sufferings, as has been held by the Honorable Supreme Court, it is like this. So, while assessing a compensation, it should not be only related to a particular part of the body which got injured, but it should be calculated as a whole.
Yes, we agree with you.
And accordingly, the learned member has, in its wisdom, has assessed that.
The only difficulty, sir, is that wisdom is not reflected in the order.
I believe my understanding is that at para 30.
That is why we say it is a speaking order. We don't say it is an order.
At para 30, six. I mean page 36. The learned tribunal has mentioned their disability, their educational qualification, promising career.
And therefore, it is your argument that therefore the learned tribunal held it to be appropriate to multiply it by the percentage of disability as given in the medical certificate. That is your argument.
Yes.
I have understood correctly?
Yes.
Okay, we will look into it. Very well. We will keep that in mind. Yes. Any other grounds you have? I will come to your application. I will come to it.
In which the amount, the other amounts, Your Worship.
Which amount?
Pain and shock and suffering.
Can you that Nicoleta?
Yes.
Read that paragraph. Can you argue that? Sir was reading it very nicely. The last part, if I am not wrong. Having not
It is-
taken the ground under 173, you are saying, no? They will not be allowed to challenge this, and quantum. So once the quantum you cannot challenge. Yes, sir. Please read that paragraph. I am not being able to find out. Let me try.
Para, this, in my list of books, I have mentioned the para 15, 16.
What is the citation, sir? Citation?
Nicoletta
Rohtagi, yes.
Yes. And my.
The citation.
My refer book.
Citation, yes, whatever you
My
refer.
refer book is 2023 volume, 2003 volume 3 TSC.
2003, just a little slowly, sir. What is it? TAC.
TSC.
TAC, what is the TAC? Okay, TAC, then
93.
2003, volume 3 and page?
Page 293, within bracket SC.
Let us see if we can trace it. It is 2002 something, no? SCC, what is it? So,
Your Lordship, I have referred para 15, 16.
yes, para 32 is important.
26 and 32, yes.
Para 32 is important for the aforesaid reasons. Our answer to the question is that even if no appeal is preferred under section 173 by the insured, it is not permissible for the insurer to file an appeal questioning the quantum of compensation as well as findings. The quantum of compensation and the findings you cannot challenge. As regards negligence or contributory negligence of the offending vehicle, you cannot question those things. If you did not take the leave at the stage of trial before the trial court. So that is how I have understood it. I will finish the judgment tomorrow. If you have anything else to change my mind, no arguments. You can just give me a judgment saying that this is what is against it.
Okay.
That much I will entertain till tomorrow.
Okay.
Okay. And sir,
Tomorrow is Wednesday, Your Worship. Division bench.
doesn't matter.
Okay, Your Worship.
Okay, it's about delivering a judgment. We just deliver it day after tomorrow, but you give it to me by today evening or at best tomorrow afternoon.
Okay.
You can leave it with my courtmaster here.
Okay, Your Worship.
So those are only your only grounds?
Yes, Your Worship.
Yeah, so the only ground that we now come down to is whether the 40% disability is correctly appreciated or not. You say it is not correctly appreciated,
Yes.
and you say that it is correctly appreciated. That is where it stands now?
Yes.
We will decide that. Yes, sir.
My lord, I've already placed my list of books. In that I have.
No, you tell me that we
Yes,
can, you just show me one judgment.
Yes, in regard to
I can-
new plea.
I know.
Yeah.
You show me one judgment that I can allow you to go before the tribunal with a photocopy of a document, allowing you to adduce evidence on that after the judgment. Can I do that? You are depending on a photocopy of a document. You want the matter remanded back because you want to show to the tribunal that you had the road permit. Photocopy is no. Is it evidence?
My lord, for that matter, if it is allowed, I can produce witness, that is the transport department, because that is the issuing authority. So since at the time of renewal of the road permit, the expired road permit was surrendered, a new road permit was issued. So that is my stand. So if it is remanded back and if that is to be taken up by the trial court, then there I will
Has the
have to.
trial court restrained you from Oh, the
No
trial
issue
court
has
said-
not, issue, there was no such issue, my lord.
No. The trial court has said the OP number 3 is directed to pay the award within 1 month from the date of the order.
Yes.
So if this order is modified to the extent that leaving you to your rights of recovery as available in law, that should do it.
Yes, sir.
It does not restrict you in any manner. The moment you try to recover it from him, he will come up with whatever proof he has to show that I had a permit at that point of time and you are wrong in a suit. Once he asks of you, then you show him that permit. Why should we prolong that
So, my lord, even
claim now?
rejecting by application should not be a bar for
No,
me
we
to
are
take.
not
Should be a bar to-
entertaining. We are not entertaining his appeal to the extent that he is trying to say that I am not liable to pay. We are not even listening to that in this appeal. We will leave you to your rights under the law to make recovery as permitted in law. Once you try to go make the recovery, and your application, I think we can close it by saying that since this is not an issue before the tribunal or it was not an issue before us, so deciding your appeal, deciding your I at this stage is of no consequence either which ways. This is a document or this is a defense you would have in case they come up with some claim.
But my lord, here in their appeal memo,
They have taken that ground. I am
Yes.
not listening to that ground is what I am trying to tell you. I am
Yes.
not listening to that ground.
yes. So
Then
they
if
have
I am not
taken-
listening to that ground, why decide your I?
That's why, my lord, since they have taken this as ground, that's why I have come with this application.
So now I am
Yes,
trying to close it
my lord.
by saying that we are not required to decide that part
My lord.
because that issue will only come up when the insurer raises a claim against the insured for recovery in accordance with law.
My lord.
And it will be open for you to have all your defenses in law that you can have.
My lord.
So you to keep fighting. Let him have some benefit. But then, sir, we are still not impressed. I still feel that the tribunal should have applied its mind to that extent. I don't know. We'll see what we can do. Should we interfere? I don't know. We will see.
Lordship, it is up to the wisdom of this, your Lordship, but the learned tribunal has, while taking assessment, has relied on the judgment of Resma Kumari
Yes.
and Pranay Sethi.
No,
And
the-
Pranay
the-
Sethi is
whatever quantification,
constitutional bench.
whatever quantification the tribunal would do, we will not interfere with that unless it is too less or too much. But what is the basis of that quantification is what we are trying to see. Whether it was quantified properly, whether there is a basis for that quantification. If we find that it had a basis, we are not interfering anywhere. It is not being remanded back, nothing is being done. If we find that there was no reason for such a quantification, then we may request the tribunal to give reasons for such quantification with due opportunity to you to show what is the loss of your income. So it will not come drastically down. Because of the disfigurement in the face, you can still have
But
a lot of.
this-
Once a reason is given, we will not interfere. Huh?
It is just a general submission.
Yes,
Your
yes.
Lordship. When a person facial is changed from the original beauty, then there are so many defects.
Yes.
He cannot even may get a
We are-
good opportunity to get a job.
We are very much with you and the tribunal on that aspect. The only thing is the order does not show that that aspect was considered. If the tribunal now says, suppose we remand it back and the tribunal says there is a disfigurement, a young child, she would not like to go to college, she will not get a proper job maybe, and therefore we hold that it should be 40%. No, it should be 50%. We will not interfere. because that is the wisdom of the tribunal. But the tribunal does not say why. Tribunal says certificate is 45, I am giving 45. Then it becomes a post office. There is no application of mind. If there is no application of mind, that is why the Supreme Court says disability certificate, if it is based only on the certificate, it will be too meager or too enormous. So there has to be some application of mind. I will just try to go through the records to see whether there was some application of mind reflected anywhere. If yes, if no, that is what we will try to find out.
Good luck to both of us.
And some more luck to me, because I will be doing all the reading.
Much
Thank you. Thank you. Thank you. Thank you.
필름 되면 23가 고치고 고치자 Take it,